think that we are going to be starting. Just one more minute to let a couple of people come in. And then we'll be starting. I just wanted to say good morning, good afternoon, or good evening, depending where you are joining from. Hopefully no good night. Okay, I think in the interest of time, we are going to start now. So greetings again, good morning, good afternoon, or good evening. My name is Maria Balsera, and I'm the Executive Director for the Center for Economic and Social Rights. I'm very, very excited to be hosting this webinar, this very timely webinar with this amazing panel. The webinar is entitled Privacy versus Transparency, Human Rights and the UN Tax Convention. This is a timely and hot topic because we are going to be exploring the opportunities of having international human rights law as part of the terms of reference for the UN Framework Tax Convention. CESR, the Center for Economic and Social Rights, has been promoting for decades now the role of human rights as part of the fiscal reform that we need. And we feel some level of responsibility because of the submissions that we have made for the terms of reference. And for, again, a really long time, the tax justice constituency has had some shortcomings, some concerns about how human rights can be weaponized to combat some of the gains, really hard gains, in terms of transparency over the years. And we have seen this particularly in some of the rulings from the European Court of Human Rights. So this panel is going to be looking at what it really means, the right to transparency and the right to privacy, and what human rights law can offer in terms of a tax convention and tax justice in general. We will be looking at this European Court ruling, at this decision of limiting public access to beneficial ownership information, and the risk of privacy being used to undermine transparency, tax cooperation, and combating tax abuse. But particularly, I'm really interested to look at possible responses to combat this risk from a robust reading of human rights law. So we are going to be starting with Professor Attiya Waris, the UN independent expert on foreign debt. So without much further ado, Attiya, over to you.
Thank you very much. I'm just going to warn you in advance, internet in Nairobi is a little unstable today, so please bear with me if I fall off, and my apologies for that. So I deliberately didn't have a PowerPoint, mainly because I wanted to have the conversation on what I'm seeing happening on the ground, not only domestically in developing countries, but in developed countries as well. So the human right to access information is not the angle that people in the finance circles are using when they talk about access to information. And so what we're starting to see globally and domestically in both developed and developing countries is actually a clash of ideology. What we're seeing is a situation where developing countries traditionally do not have a good experience of human rights. But in the case of access to financial information, the human rights assessment of access to information actually can be very positive for developing countries to access information not only domestically in their countries, but actually globally, and specifically from multinational corporations, for example, that hold a lot of the data and collect a lot of taxes in the developed world can actually be shared downwards into developing countries. So it is a positive tool for developing countries to use, but the traditional backlash around human rights has often been that it is used as a stick. And so the result of that is that more often than not, the developed countries are continuing to actually fight off the language of human rights when it comes to fiscal spaces, and they see it as a threat, when in actuality, it actually could be a benefit. But then that brings me to the whole conversation happening in the global north, which is the use of the right to privacy, and specifically within countries like the EU and some Latin American states, where multinational corporations have traditionally been given a human rights protection. The result of that now is that the right to privacy is being used by corporations domestically And when data is being requested of them at a global level, there is a pushback on that whole conversation. So what starts to happen is an approach to the ideology, where on one hand, countries are using it in one particular way, and in another, they're using it from a different direction. Now, because we have the UN Convention being debated at UNGA, and it'll continue later this year, and I'm sure into the next year, with the final deadline of 2027, what we are starting to see is deep conversations first on removal of human rights because of that very issue that I've pointed out, but also a need to define it. And I think that this webinar for me comes at a very important time, because it is really clear to me that we need a crystal clear understanding of what the access to information should look like, who should access it, how they should access it, perhaps how they should not access it in certain scenarios. But when it comes to the data and the access, we need to be extremely clear on it. And while there is concern around protection of those that have the amount of money that can cause threats to their personal security, I think at the end of the day, it's very important that countries collect their fair share of taxes. And I think finding the balance between the two is going to be very interesting. I want to stop there because I also really want to hear about what the others have to say, especially in light of the new decision. I'm sure they're more up to date on it than I am. And I look forward to the questions. Thank you, Maria. Back to you.
Thank you very much, Attiya. Now, our second speaker is Asha Ramgobin, who is the Executive Director for Human Rights in the Development Initiative. And we have a question for you. Why are tax transparency and access to information relevant for tax justice and combating illicit financial flows? Asha, over to you.
Thank you so much, Maria, and thank you, Attiya. That was a perfect way of framing the issues. I agree this conversation is exceedingly timely and very necessary, I have to say. Over the years, we have all learned that tackling secrecy and opacity within the banking, financial, and taxation sectors is crucial to stemming illicit financial flows. In fact, just under 2 weeks ago, Alejandro Luck from ICRIT wrote a piece advocating for a global asset register. And he opened his article with these words: financial opacity and offshore hidden wealth are structural economic and political problems in today's world. Close quote, he argues that despite the wars, growing inequality, and decline in democracy the world over, within a state of a climate emergency as well, we still witness how financial opacity continues to exist, offering financial secrecy services that allow the world's richest individuals and criminal organizations to hide their wealth from tax, anti-money laundering, and anti-corruption authorities, close quote. Alejandro was making the point that in Brazil, as Brazil hosts the G20, that they should not only be advocating for a wealth tax, but that they should be advocating for a global asset register. And he makes the point that it was not a new idea. In fact, about 5 years ago, ICRIT, the World Inequality Lab, Tax Justice Network, Transparency International, and Financial Transparency Coalition met in a workshop where they were discussing the establishment of a global asset register built on foundations of the current beneficial ownership registers, etc. So to be clear, the beneficial ownership register is not the problem in itself. Rather, as Attiya was saying, who has access to the information in the register is under threat. Andrés will discuss the challenges to the Luxembourg Business Registry cases before the European Court of Justice. But for now, briefly, all that I would like to say about that particular judgment is that that court reasoned that a fair balance should be sought, in particular, between the general public interest in the prevention of money laundering and terrorist financing on the one side, and the data subjects' fundamental rights on the other. Unfortunately, in the end, they concluded that requiring these registers to be accessible to the general public went too far. So for today, what I have decided to actually look at, generally I'm focused on international and regional human rights mechanisms, but today I've decided for us to look at the South African Constitutional Court and the Kenyan High Court, and to look at two judgments that come out of these jurisdictions to guide us on this kind of robust human rights framing on the issue of access to information. So the South African Constitutional Court took a very different approach in a case that dealt with what would be a more sacrosanct privacy issue in a sense, the secrecy of taxpayer records or taxpayer confidentiality versus the right to access information and freedom of expression. The case was the case of Arena Holdings Pty Limited versus the South African Revenue Services, the Minister of Finance, the Minister of Justice, etc. And it was between Arena Holdings was a media house, a big media house, right? So I will highlight three elements of this judgment. First, how the court balanced the right to privacy and taxpayer confidentiality with the right to access to information, the right to freedom of expression, and the public interest on the other hand. I will then look at the weight that the court attached to the position on taxpayer confidentiality in the UK and Canada, as opposed to Kenya, for example. And then the last point that I would make is how the court dealt with the issue of absolute prohibition of disclosure of taxpayer records on the one hand, and absolute transparency on the other. So let's start. As a starting point, the court then said, no right is to be considered absolute. No right is to be considered absolute. This implies that from the outset of interpretation, I'm quoting from the judgment, each right is always already limited by every other right accruing to another citizen. In the context of privacy, this would mean that it is only the inner sanctum of a person, such as his or her family life, sexual preference, and home environment, which is shielded from erosion by conflicting rights of the community. This implies that community rights and the rights of fellow members place a corresponding obligation on a citizen, thereby shaping the abstract notion of individualism towards identifying a concrete member of civil society. Privacy is acknowledged in the truly personal realm, but as a person moves into communal relations and activities such as business and social interaction, the scope of personal space shrinks accordingly. Close quote. In this case, as I said, a media house applied for access to former President Jacob Zuma's tax records under South Africa's access to information legislation. The Revenue Authority refused to provide the information, and they relied on Section 35 and Section 46 of the Promotion of Access to Information Act, and on Section 67 and Section 69 of the Tax Administration Act. All of these sections protect taxpayer information and protect taxpayer secrecy. So the majority judgment found that these provisions entailed absolute prohibitions of disclosure of taxpayer information. They looked at other judgments of the Constitutional Court and concluded that absolute prohibitions were unconstitutional. For example, in divorce legislation to protect children, in refugee legislation to protect asylum seekers, it was concluded in those cases that absolute prohibition, even where these vulnerable groups exist, was unconstitutional. So in this case of Arena Holdings, the judge made this very important statement where he says, one must be careful not to elevate taxpayer confidentiality to some sacrosanct place where no exception to enable public access to it is possible, where taxpayers do not even constitute a vulnerable group like children and asylum seekers. So the next area that I wanted to look at is how, and I think it's related, how this court dealt with references to the UK and Canada. The minority judgment, the commissioner of SARS, all made reference to taxpayer secrecy provisions in other jurisdictions, comparing the UK and Canada and citing long-standing taxpayer secrecy policies. But significantly, the majority judgment found that these references are of, as they said, limited assistance. Instead, they looked to the High Court of Kenya in the Njoya versus Attorney General judgment, where taxpayer secrecy provisions under Section 125 of the Kenya Income Tax Act was successfully challenged as being inconsistent with the right of access to information guaranteed under Section 35 of the Kenyan Constitution. The court ordered the disclosure of tax information of individuals relating to their parliamentary salary allowances. So while both the South African Constitutional Court and the Kenyan High Court acknowledged the globally recognized concept of taxpayer secrecy, and both noted the age-old British and Canadian policies, both judgments were clear that the right to information is critical to the attainment of transparent and accountable government, and that reference to international comparisons depends on factors such as prevailing legal culture, the existence of a written constitution that you don't see in the UK, for example. So, and the time period when the law would have been enacted. So they didn't just adopt the British and Canadian policy and make their ruling based on that. Coming now to the last point, it is also important to note that while the court was not prepared to protect a right to absolute prohibition of disclosure of taxpayer records, at the same time, it was not prepared to grant an order for absolute tax transparency either. It found that neither extreme is tenable in a constitutional democracy. Instead, the process of balancing rights is important. And in South Africa, the framework for balancing competing rights is contained in Section 36 of our Constitution, where any limitation needs to be reasonable, justifiable, and proportionate, taking into account the nature of the right, the nature and importance, the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, and the less restrictive means to achieve this purpose. So international human rights law has a similar set of factors that need to be considered when deciding on limitations. The right to access to information is a core component of the right to freedom of expression and is contained in Article 19 of the ICCPR. General comment number 34 on Article 19 states, and I quote, "To give effect to the right to access to information, state parties should proactively put in the public domain government information of public interest. State parties should make every effort to ensure easy, prompt, effective, and practical access to such information. State parties should also enact the necessary procedures whereby one may gain access to information, such as by means of freedom of information legislation." So to conclude, Amartya Sen found that there was never a substantial famine in a country with a democratic form of government and a relatively free press. He argued that inequality of access to information is a form of poverty, and that without knowledge, you cannot act. So I would argue, going forward, that we should counterattack. As they are weaponizing the right to privacy, our response should be a counterattack. Firstly, to challenge the taxpayer confidentiality exemptions within the access to information legislation and within tax legislation. Secondly, to push the outer limits of access to information to move beyond the public sphere to the private sphere. We have precedent for that in South Africa again. And third, to advocate for a public interest override provision if it is not already included in these laws. Thank you.
Thank you, Asha. Great presentation. So now we are going to move to Andrés Knobel, a lead researcher for beneficial ownership for the Tax Justice Network. The question for you, Andrés, is can human rights be weaponized to impede transparency? And how was the right to privacy claimed before the European Court of Justice to restrict transparency? Andrés, over to you.
Thank you very much for the invitation. Great comments, Asha. I wish I knew some of those case law. I would have used. I mean, we actually said some of the same arguments. The interesting thing, though, is that from what I understood, those cases referred sometimes to the president or to a member of parliament. And sometimes there is some consensus that, well, they maybe deserve less privacy than others. The problem with beneficial ownership is that what we expect is that no one will actually enjoy that special provision, or basically that all the public, when they decide to be beneficial owners, they should have in principle to give access to their information. Of course, there are exceptions. So I will, as described, I will refer to that case of the EU. But before that, just to make sure that everyone is on the same side and understand the same things. A beneficial owner always refers to a natural person that ultimately owns or controls a company, no matter what's in between, a trust, a partnership, or a company. Now, if we were able to connect this with asset ownership, because in most cases, say a house, a yacht, a private jet, livestock, or even patents are owned by companies, then we could also know who are the beneficial owners of assets as well. And then that could be used for many purposes, from anti-money laundering, for tax abuse, or for the enforcement of wealth taxes, which is another thing that is being discussed now within the UN Tax Convention framework, for anti-corruption, for the well-functioning of markets and investments, for climate change and illegal fishing, and even for gender cases, because many times beneficial ownership, we find out about it in divorce cases where a spouse is affecting usually their former wife. So even though beneficial ownership has all of this potential, in the case of the EU, again, without the public access, it was actually quite limited. And this will have implications to understand what the ruling said and why it said that. So it covers beneficial ownership, but only of companies and some trusts, although there was no public access to trust information. And the goal or the main framework of the EU directive and the framework that gave this public access was AML, anti-money laundering and combating the financing of terrorism. And that's it. And this had implications on the court ruling. Now, the interesting thing is that this ruling from 2022 didn't address an overlooked issue. It's not like all of a sudden we had public access and, oh, no one realized that that affects privacy, so we need a ruling to come and tell us that that's wrong. Public access had been a deliberate decision based on past challenges. And I want to show here a bit of the evolution of how things happened. So in 2015, we had the fourth anti-money laundering directive, which first established a central bureau register, so beneficial ownership registers for legal persons at least. And in that case, access was based on a legitimate interest. What happened then? We had the Panama Papers, where we could finally see the benefits of public access and to truthful data. I mean, the leak showed the right data. Public beneficial ownership registers don't always show the right data. Many times they have inaccurate data. But for the first time, the Panama Papers showed how relevant this data is to fight not only money laundering, but also tax evasion and again, corruption and many other things. Even Global Witness, another NGO, was able to analyze the UK beneficial ownership register and find tons of inaccuracies. And since then, verification and the need to have accurate data also became a thing. Before that, we had no idea how bad or good it was, just because it was confidential. We also had terrorist attacks in the EU, which made the point that there's a high direct cost. Now the question is terrorism the only direct cost on human lives and freedoms? And of course, I'm going to challenge that. So based on these two things, especially the Panama Papers, the terrorist attacks, and also the limitations of the fourth directive, we had the famous directive of 2018 that established public access for legal persons, but it still added exceptions. It wasn't this absolute transparency, as Asha was saying. If on a case-by-case basis, someone could justify that there was a risk, then there would be no public access to their information. For trust, they kept legitimate interest, and again, this analysis of accountability and getting the information right was established through discrepancy reporting. Then in 2022, we had the ruling that basically said, go back to legitimate interest. So avoid AMLD5, forget about it, and go back to these provisions of AMLD4. The FATF, which is an international organization with recommendations 24 and 25 that deal with beneficial ownership of legal persons and trusts, they revised their recommendations, even though they had been acknowledging this tendency towards public access. They didn't really prohibit or require public access. We think that was also a missed opportunity. And in the end, the AML package that was approved in March or May of this year, in a way extended, had this wide legitimate interest that covers both legal persons and trusts, but it still has exceptions. So what the EU found is pretty good given what the ruling said, but of course it's not enough and it's not good, good replacement for public access. Now, what had happened in terms of countries? So in 2016, we had the first examples of countries offering public online access and also for free, the UK and Ukraine. The UK was supposed to extend this to British overseas territories. Think of the Cayman Islands or the British Virgin Islands. Ecuador in Argentina, in Latin America, also started giving free public online access. It still does. In 2020, the fifth directive became enforceable. So in principle, the 27 members were giving this or were supposed to give. And this also expanded to Eastern Europe, and countries like North Macedonia or Serbia also started giving public online access and for free to beneficial ownership data. And so did Indonesia. Now, when the ruling happened, some, but not all, and that is also positive, of the EU countries closed them, of course, and with Luxembourg, Ireland, the Netherlands, Austria, Germany, Belgium. And since then, British overseas territories and even crown dependencies have said, yeah, well, there's a ruling, we won't even go fully public, even though, of course, the ruling is not binding on them, and even though the UK has already required them to go public, but many of them, except for Gibraltar, are still refusing to go there. Nigeria is also expanding, Canada also approved that, and Australia and Argentina are in a way in between. They're supposed to give public access or planning to, but hasn't happened yet as it's supposed to. Now, what did the ruling say in practice? It basically said, as I expressed earlier, the fifth directive, the fifth AML anti-money laundering directive that amended and established public access is invalid. So it goes back to the fourth directive, legitimate interest access. The good thing, though, is that, again, if we think of the world, the EU was quite progressive, and Eastern Europe as well. But in the rest of the world, we only had maybe Ecuador, Indonesia, Nigeria, some of the countries working or even establishing public access. So the ruling does have a positive thing, which says civil society organizations and investigative journalists do have a legitimate interest to access BO data. So of course, public is much better, but the rest of the world should be paying attention and realize that CSOs and investigative journalists, even for a ruling that is highly regressive in terms of transparency, is still acknowledging the right of civil society and journalists to access this data. Now, what did the ruling say in practice? So there was a serious interference to privacy and data protection. And some of the arguments were that beneficial ownership gives information on wealth. And so there's this risk of kidnappings. And I would answer, if only. I mean, as I showed in the slide, we wish beneficial ownership registers would say anything about the wealth. Then we would finally have this guard that ICRIT has been talking about. And of course, the Taxes Network has been supporting. It doesn't say anything. A company that you own might pretty much be a shell company that owns nothing and is only used for tax avoidance or money laundering purposes without owning any asset. So the fact that you own a company doesn't say anything about your wealth. The other point was unlimited access because of these at least. I mean, that's what the directive said, is that the public would get access to at least the name, the month and year of birth and other things. And again, we could ask whether, or we could discuss whether at least was appropriate or not, but the directive had proper exceptions that were implemented in most countries. But still the ruling, not very clear why, they thought these exceptions were not enough. I feel like one of the biggest problems is this idea that anti-money laundering, so the fight against money laundering, is only for authorities or financial institutions like banks. So what's the added value of the public? And so the ruling was challenging that. I would first answer accountability. I mean, as Global Witness showed, without public access, we have no idea whether the registries are working or not. I mean, we have no idea if they have any good data or bad data, if companies are complying or not complying. We simply have to blindly trust authorities. And at the same time, we need all the help we could get. A report by the UNODC, it was a bit dated, but most likely still is true, is that only 1% of money laundering cases are caught. So again, clearly what authorities and banks are doing are not enough, and they do need the help of the rest of society. And the ruling finally said the other benefits, such as fighting the misuse of companies, is not necessary for anti-money laundering. So that's not a justification of why to give public access within the context of an anti-money laundering directive. And of course, we should answer, well, money laundering is not the only relevant crime. So many countries in the EU are now outside the EU, like the UK, they kept on their registries public because it said our register, our BO register, is not only to fight money laundering, it's also to defend the market and democracy and the well-functioning of things, and also to fight corruption. So that's why we need to think, and the ruling could have considered, or the court could have considered, these other purposes, even if they were beyond the directive. Now, what is part of the framing that we responded? I mean, even though there was these specific arguments by the ruling, in general, we wanted to say privacy is different from secrecy. So don't mix the same, and don't pretend that every time someone is trying to remain secret, especially about their ownership or their financial affairs, to be a matter of privacy. And at the same time, as Asha was saying, you cannot expect secrecy in the public sphere. One thing is what you do in your own house, and basically, if it's about, again, your sexual orientation, your religion, your political views. When you start incorporating companies or creating trust that will have an effect on the rest of society, for instance, because your limited liability, so that will affect others, you cannot expect the same kind of secrecy that you would do if you stayed in your private sphere. When you go out, again, in the creation of companies, don't expect the full secrecy or privacy that you would expect in your own house. As I just said, public beneficial ownership is not really about any sensitive data. That doesn't even cover wealth. I mean, we wish it did, but it doesn't yet. It's only about your interest in companies that might as well just be shell companies that have no operations and no real activity. As Asha said, and I feel like that's a wide-known issue, no right is absolute, no the privacy, nor transparency. And we also, and the court should have considered the right to information and other rights that depend a lot on the money that is lost to illicit financial flows, such as the rights to health, to housing, to education, or to a clean environment. Now, one last point is that maybe when we think of human rights and we think of NGOs, they tend to be protecting the vulnerable people, like migrants or low-income people. Now, this case had nothing to do with that. The plaintiffs of this case were clearly not vulnerable people. They were actually showing off their private jets, trips, and their dinners in private restaurants and private clubs in London. So we should also consider who is really asking for this when we consider what are the implications here. And this gives to the last point, which is equality before the law. Public beneficial ownership, as it stood, would only help, or basically the lack of public access would only help criminals and high net worth individuals who use complex ownership structures, as I showed, like when you own a company through many, many layers of companies and trusts. Because if you are, as most people in the UK, 85% of all companies, using a very simple structure, basically you create a company and you directly own it and there's no one else, no offshore entities, no nominees, you directly own it, that information has been public for decades. Because most commercial registers that give shareholder data, they were public, they were always meant to be public. They're even called public registries in many countries. So for most people, their information had already been public even before the fifth directive. The only thing that changed was for these people creating complexity. That is the only new transparency that we're getting, and now we lost because of this ruling. So what are some of the lessons that I think we can learn from this? There is a problem when we think of like, what is the law or what the UN Tax Convention should say, when that issue, such as public access, has a legal framework, such as a directive, or again, could be a tax convention that has a very narrow focus. To say this is only for tax and we don't care about anything else, or this is only for anti-money laundering and nothing else. Well, the wider the goals and the purposes, then the more likely it is that there will be some reason to justify why another stakeholder should get access to the data. I think there's a very big problem, and we have to definitely change this, of the view of the role of civil society and journalists. This idea that only authorities fight crime, it's not only dated, but again, doesn't even work. And there's another issue, which doesn't have to do with fighting crimes, which is accountability, making sure that the government and authorities are doing what they are supposed to do. Without public access, we have no way to do it. We have to simply blindly trust them, which of course doesn't work. And then I feel like at last it was this problem that I feel like sometimes American judges have less of a problem, but sometimes continental law, at least I've seen that in Argentina where I'm based, is that there's almost like little awareness or respect for the situation in practice. Legitimate interest access didn't work properly. Again, it's not like that was the first thing that we did. We went from 0 to public access. In 2015, they established legitimate interest access. It didn't work. When we ask authorities, so this was a paper also done by Transparency International, when they ask authorities, They would even prefer using the public access route than even their authorized confidential access, because it was easier to get it and to get their job done. So public access actually worked while legitimate interest didn't work in practice. And another thing is that most of the crimes we're talking about, tax evasion, money laundering, they are transnational crimes. So it's not enough to give access only to a local authority. We need foreign authorities to also get direct and easy access. And even asking for a request of information usually doesn't work very well. So public access is the best way to ease resources for them to be used in more proper goals, like verifying information. Now, the worrying thing is that this ruling wasn't an isolated issue. It's not that privacy is only being used against public beneficial ownership. This has also been used against automatic exchange of information, especially this exchange of bank account information. In Belgium, they tried and initially succeeded in stopping exchanges between Belgium and the US. In the UK, there was crowdfunding and an anonymous donor paying someone, almost like a nominee plaintiff, to go and try to also stop automatic exchange between the UK and the US. A very worrying, I think like even more worrying than the 2022 ruling was a ruling this year that even prevented upon request access by a tax authority to get access to lawyers setting up companies. Again, this involved Luxembourg, and again, the ruling extended privacy and even professional confidentiality for law firms setting up companies. I think this is even more worrying against than the 2022 case that I prepared about and I presented about. About beneficial ownership, again, it's not only this case. In France, in 2016, the court stopped public access to trust information. In the US, it has also been used to oppose the BO law, the Corporate Transparency Act. And I found out that there has been a submission now by Italy, again to the ECJ, about whether, again, against the public BO register, not even the public one, just the BO register in general in Italy. And lastly, there's a great thing, a great tool, which are these mandatory disclosure rules, where basically they ask lawyers, accountants, or tax planners to report to authorities any scheme that they are offering to clients to either engage in aggressive tax planning, basically tax abuse, or to hide the beneficial owner. This was incorporated by the OECD under BEPS Action 12, and the EU implemented this in DAC, in the 6th Directive DAC. But still, in many countries like Belgium, Argentina, Brazil, and Ecuador, based on this issue of privacy or confidentiality, professional confidentiality, the courts struck either the whole system down or at least partially. So what do I think, and I will finish here. What do I think our role is? We have to explain what this weaponization of privacy is looking, and also of professional secrecy and how it works and how to tackle it. We need to redefine the balance in favor of economic and collective human rights. And again, human rights of humans, rather than this idea of human rights of multinationals or law firms. And explain the cost of life of corruption, money laundering, and tax evasion. Again, even some privacy expert told me, you know why there's a difference, especially when we think about airport security and how not only presidents have to go through airport security, or not only terrorists, but pretty much everyone goes through airport security. And he said, well, terrorism is very present. We think of 9/11, and again, this terrorism is directly a loss of life. So there's this idea that terrorism might justify interference with privacy, but money laundering, tax evasion, or tax abuse, or corruption don't. Well, I think we need to also work on that to show that even if it's less immediate and it might be a bit more remote, they still have the same consequences for life and for freedom. I'll stop there. Thank you.
Thank you very much, Andrés, for a very thorough and excellent presentation. Now we are going to move to my colleague, Maria Emilia Mamberti, who is the interim co-director of program for the Center for Economic and Social Rights. Maria Emilia, the question for you is, where are human rights in the current process to negotiate a convention on tax cooperation at the UN? And what can human rights bring to the convention? Emi, over to you.
Sure, thank you, Maria. So first, very briefly on the context of the tax convention. For those following who are less familiar with the process, this is an ongoing process to try to come up with a legally binding convention on tax cooperation, a framework convention in the UN. And this process has been a massive success, pushed forward with the leadership of African countries, and has been a long demand of civil society organizations, many of them present here in this virtual room, after years of documenting the lack of inclusiveness and effectiveness of the processes being led on international taxation at the OECD. So where is this process at the UN right now? Recently, a committee that was tasked with drafting the terms of reference for this convention approved them. The terms of reference are yet to be voted by the General Assembly, but we expect they will. And these terms of reference include explicit reference to international human rights law. So the general or guiding principles for the convention state that basically efforts to achieve the goals of the convention should be aligned with international human rights law. Introducing human rights to the tax convention has also been a core demand of many civil society organizations and some human rights mechanisms at the UN, some of them also present in this virtual room. Of course, the outcome of the text is a compromise text, as always in these negotiations, but what's interesting here is to understand the different views that the human rights language trigger in the context of these debates, because they represent many of the different angles or viewpoints that we have been discussing today here. So one view that was that of the countries actually suggesting the language is that we typically would relate more to social rights, that is, introducing human rights as a way to mobilize resources for this end and not others, and to mobilize them in certain ways that are accountable, fair, and I'll get back to this in a bit. A separate set of views is what Attiya pointed out to earlier, that is a view that expressed concerns over human rights by understanding more human rights as political and civil rights, and fearing that there would be some backlash because of incompliance or alleged incompliance with civil and political rights in the convention. So it's more of a monitoring approach in which some countries argued that including human rights in the convention could be a way of punishing them and depriving them of exercising some of their rights in the convention because of incompliance with human rights in other fields. And a third kind of broad view on human rights is that mostly of the European countries, but not only of the European countries, that of equating human rights to taxpayers' rights. Right? Of course, taxpayers' rights encompass a broader set of rights, like the right to property or to due process, but mostly the sense was that the discussion on taxpayers' rights related to the conversation we're having today on the right to privacy. So that is where the process is right now. We have a compromise text, but we're still very happy about. And there are different views among the negotiating countries on what this actually means or should mean or should be read to mean in the future. So with this, I'll address the second part of the question that Maria asked on the value add. And here, to me, it's good to clarify the scope of international human rights law in connection to taxation. Because in CSR's view, at the UN level, and to a fair extent at the inter-American level, the development of standards around taxation and human rights actually relates much, much more to treaty provisions that connect to economic, social, and cultural rights, rather than civil rights, such as the right to privacy. So the bulk of the development of this law and literature and jurisprudence has to do with social and economic rights. And under this understanding, right, that what has been typically interpreted by UN human rights mechanisms and is incorporated in UN treaties in connection to taxation, relates to states' duty to mobilize the maximum of available resources for the realization of social and economic rights. So when we frame the issue as such, we understand that a first value add of introducing human rights in the tax convention has to do with the purpose that human rights give to the UN tax convention. Because for many in the human rights field, saying that enhancing tax cooperation and tackling tax abuse is an obvious tool to ensure human rights and to fulfill human rights. But that is not always obvious in tax conversation. So achieving social rights, as Andrés just discussed, is not always explicitly recognized as a goal of this effort. So there we have a first value add. And then the second value add has to do with all these standards that I was just referencing that are key to interpret the future convention in a robust manner. And so as I mentioned, the core provision, which is a treaty provision that is included in many human rights, well, at least 3 human rights treaties that are widely ratified across the world, has to do with this duty of mobilizing resources for the fulfillment or full realization of economic and social rights. So this provision that I would say bind virtually all states in the world, maybe with 1 or 2 exception, calls states not only to mobilize current resources for this goal, but also to mobilize additional resources that could reasonably be mobilized if some measures can be taken. So this broad reading of this treaty provision, so hard law, has been read to mean things like a duty that states have to combat effectively tax abuse. So, and for example, acknowledging this in the convention could be a step forward, because it's not only always clear that this is a duty, a legal duty to effectively combat these practices. Other things that are a bit more specific to the convention could have to do, for example, with discussions on minimum taxes. What is it an effective or a good tax rate for a minimum tax? These discussions typically go on ignoring that states have a duty to mobilize the maximum available resources. So minimum taxes should be sufficiently high to ensure that sufficient resources are being mobilized. Sufficiency is another standard emerging from this literature. Other impacts of this standard, conducting estimates, not only of revenue potential of the measures that are being advanced, but revenue potentials for each country, so that these measures are equitable among countries. And they are in line with the financing need, the financing needs that states face to combat poverty, ensure sustainable development, and discharge human rights. And of course, then this is a framework convention, so we still don't have a ton of clarity on where the issues it will tackle, but this standard of maximum available resources could be relevant for other issues such as tax benefits. So I'll touch upon briefly 2 or 3 other standards and wrap up with our reflection on transparency in human rights. Second standard, also like widely recognized across human rights treaties, I think basically all of the core human rights treaties, equality and non-discrimination. And this is key for the tax convention. And in my view, this standard can function as a gap filler for the things that we may fear that may not end up in the convention as such. And this is very obvious, for instance, right now for the gender equality piece, which we see missing in the TORs. And this broad reading of human rights as protecting equality and non-discrimination in a robust way is key to fill in this gap. So again, the bodies that interpret authoritatively these provisions have read a duty to promote socially fair tax systems, right? Or equitable tax systems. And this is key for the tax convention. First, to ensure interpretative coherence among UN entities, because we wouldn't want a convention to read equitable taxation in contradiction with how the Committee on Economic and Social Rights reads equitable taxation, because in the end, they're part of the same organization. And this is a huge potential of having a tax convention at the UN. And then these principles also show the importance of considering issues of inequalities in international taxation, which are not necessarily considered in current international taxations debate. This could suggest, for example, that some strands of work could be prioritized, such as those that relate to taxation of high net worth individuals. So it's tools to enhance equality or to increase equality, but may also require more instrumental issues such as impact assessment on different groups with an intersectional perspective of the measures that are advanced at the convention. Another, very briefly, gap filler of the human rights, gap filler role that human rights can play in the convention has to do with extraterritorial obligations and the duty to cooperate internationally to fulfill human rights. Unfortunately, at this stage, the approved draft of the terms of reference distorted or deleted an initial reference to understanding and assessing the impact that states' decisions have on other states. So having human rights currently at the TORs could be a good way to still consider extraterritorial obligations as included in the negotiating text, right? Because human rights very clearly determined that that states can not only violate human rights within their borders, but also beyond their borders. And this is critical for a tax cooperation treaty because of the nature of the problem that it tries to tackle, but also because of the nature of cooperation. And finally, on transparency. So it's clear that international human rights law does not have a definite answer on the balance between tax transparency in the sense of disclosing information that is relevant for tax cooperation to the public and the right to privacy. As Andrés and Asha have discussed, this is very context specific. Different countries and regions have different stances on it. The current landscape is not kind of clear. We're unsure as to what to expect. And in the end, the most restrictive outcomes, which are those that Andrés just discussed, emerge from a very specific analysis that is a proportionality analysis that is very, very tied to the regulation at hand. So overall, the truth is that this is a contested issue in international human rights law. I would dare to say that there's no agreed international human rights law standard, either suggesting that this should be one way or the other. So in this context of uncertainty, which is also very typical of law, is not a problem of this specific issue. Those of you who are lawyers would know this is a regular problem that we face. So what do human rights bring to this specific discussion? So in my view, the first value add is a different angle. And I think Attiya led with this and others also discuss this, which is the more access to information angle, and also not only discussing what information that states have from individuals goes into the public, but what information states must produce, how they should produce it, and how they should publish it. So human rights mechanisms have read transparency in connection to economic and social rights and taxation to call for states to produce, for instance, specific information on impact of these measures on specific groups, and have called states to publish this information in accessible manners and in timely manners. And there are many standards on what states should produce and publish with the information that maybe does not even refer to a specific person, but that today is missing to ensure that tax systems can be assessed from an equality point of view in many countries. Then the second piece, and I love that Andrés introduced this, is I think that social rights in particular can provide evidence for future proportionality tests, because they can show the impacts, the concrete impacts, if we produce good evidence, the concrete impacts that tax abuse can have on certain human rights. So if we work together to build this evidence, then doing this proportionality test in a lighter way should be harder. This is a bit of wishful thinking, future work, early stages, but I think it's an idea worth exploring, how we can build evidence of the relevance of this to assess this goal media test in a different way. And finally, I think that the third value add of international human rights law around this is to move a bit beyond the Europe-centered discussion, because it's not the case that there's similar case law in other regional mechanisms. So for instance, in the inter-American system, there's a strand of cases that have the access to information angle and not necessarily the privacy v. transparency angle, but that sets standards that I would say would really conflict with the decisions and future decisions of the European Court, and that state principles such as maximum disclosure, or define a very, very broad standing, which might be in some tension with some readings of what legitimate interest is, and well, there are a bunch of other principles derived from that case law, which to me make me think that international human rights law does not have one answer that is that just presented by Andrés, because other regional mechanisms may be going in a different directions in their decisions, even though if they did not decide on a very, very similar case to the one in Europe. So I'll leave it there so we have time for questions.
Thank you very much, Maria Emilia. I would like to remind everyone that they can use the Q&A option, which is at the bottom, to ask some questions. Now we are going to go for a much faster and quicker round of questions. And the first one is for Attiya, which is, how have human rights special procedures engaged with the issue of taxation of human rights? Attiya, over to you.
Sorry, could you repeat the question for me? I'm sorry, my internet is really bad right now.
How have human rights special procedures engaged with the issue of taxation of human rights? That's a quick answer, please. Thank you.
Thank you. So special procedures have mainly been engaging on tax issues from my mandate. I think that's the big answer. I have been looking at taxes, and other mandate holders have been looking at the issue of taxes as how they have impact on the living standards, poverty, and development of countries on the one hand. And in other cases, for example, in the case of Israel, it was a question of the withholding of taxpayer money from the Palestinian Authority that then blocked their ability to provide services and pay for electricity, for example, that resulted in additional deaths in the hospitals. So there's a real right to life connection to tax, as in that particular case. And then on the other hand, making input, for example, into the TORs of the tax convention and ensuring that language such as human rights is there. So increasing visibility on the one hand, and then in other spaces, trying to really show how tax and state revenue has a direct impact on the lives of human beings. Thank you.
Amazing. On the spot as well, very fast. Okay, Asha, now the quick question for you is, how can we engage with human rights mechanisms strategically to ensure progressive readings of transparency and access to information?
So just to say, I've done a study of the UN mechanisms, both the treaty bodies and the charter mechanisms. And just to focus on two elements. The one is the to worry, that might be of concern to us. The Human Rights Committee that's responsible for monitoring the implementation of the International Convention on Civil and Political Rights raised a concern just this year, at the beginning of this year, on the UK's Data Protection and Digital Information Bill. The concern was that it would establish new powers, forcing banks to monitor the bank accounts of what it called benefits claimants. So, some organization must have given the Human Rights Committee this information, which prompted them to raise this issue with the UK. So what I would suggest is that while we are engaging, and the low-hanging fruit certainly is the Committee on Economic, Social, and Cultural Rights, CEDAW, the Children's Rights Committee, we really do need to engage with the Human Rights Committee, particularly from an access to information, freedom of expression perspective, right? And as pertains to special mechanisms, I would suggest that we also include Irene Khan, the Special Rapporteur on Freedom of Expression, so that she also develops thematic reports on the importance of access to information, expanding, in a sense, the realm of access to information from just the public sphere and private actors engaged in public activities to actually private sphere more deeply, and on the secrecy, taxpayer secrecy, and these exceptions as being unconstitutional or going beyond the limitations clauses of the UN. So just in summary, the Human Rights Committee, I would say, needs to be engaged on this access to information element, and the Special Rapporteur on Freedom of Expression as well, that we need to actually be moving into that field. Otherwise, all we're going to have are standards on the right to privacy. So we have to do this. I don't think we have a choice.
Perfect. Thank you very much, Asha. Andrés, I think that there is a question here in the Q&A for you. So I'm going to read it. This is from Matthew Forget, which is, thank you all so much for the illuminating presentations. I learned so much. There was some discussion around this use of the right to privacy to push back on the right to access to information as representative of a broader trend, particularly in the global North and EU, of preferencing individual civil and political rights over collective economic, social, and cultural rights. If so, what can be done to combat this interpretation and, as Andrés put it, redefine the balance in favor of economic and collective human rights? Andrés, over to you.
Yeah, thanks and thanks for the question. And I feel like these are some of the I think issues we need to explore and in a way try to expand more. So I think like one of them is this collective over individual. So of all the society to housing, health, education over just one's to privacy. The other one that I say is this maybe saying, well, direct rights of humans should be prioritized over the indirect of the company. So basically, because the argument says, well, even a company might have human rights because there's some beneficial owner behind it who is a natural person, so they also have rights. Although there was this case that was expanding. I mean, at the beginning, there was this recognition in Europe saying, well, when your name as a shareholder or as a partner appears in the company name, then you also have some right to privacy. But in this case, from this year, they still expanded it to just a law firm that had nothing to do with that. So I feel, again, collective over individual, direct over indirect. And then I think one last one that I think we could explore and try to expand more is this idea that there's one thing about like privacy regarding sensitive issues, religion, sexual orientation, political views, over privacy regarding your property or even just your interests. So I feel like, again, sensitive issues might require more privacy protection than what you own. Of this specific issue of collective over individual, Latvia gave this answer. So Latvia decided to keep the register open despite the ruling, and that's pretty much what they said. They said, well, even if if there's a conflict of rights, clearly, as it usually happens in law, and if we have to prioritize, there's a principle of like, well, then the rights of the majority over the rights of just one person. And that's what they said. I mean, we have this interest, especially with what's happening between Russia and Ukraine, and the need to protect Latvia's economy and trust and everything. And they said, we decided that's why for this collective and thinking of the whole society over just a few rights of individuals. And that's pretty much what they said. So I think we need to explore a bit more. Of course, human rights always come more this idea that, well, we're just not gonna let majorities go over the rights of a minority. But that's, again, when we're thinking about vulnerable people that without human rights would not get any protection. But when we think that this is actually asked by really powerful individuals, that's when I think we have to be a bit more careful. And I don't know how to express that as a human rights principle, but I think, yeah, we need to work on that.
Perfect. Thank you very much, Andrés. We have another question, and Attiya has volunteered to answer. I'm going to read the question, which is from Juan Ignacio Pérez Bello, which says, recent CESR committee recommendation on Malawi tackle the debt servicing and illicit financial flows quite in detail. Are these new developments, or is it a repetition of previous recommendations from these treaty bodies? For instance, they include this: combat illicit financial flows through mandatory due diligence mechanisms in the national financial system and strengthening tax administration, and F, foster international tax cooperation to tackle tax evasion, cross-border tax avoidance, and financial crimes, and consider seeking the assistance of the Tax Inspectors Without Borders initiative. Attiya, over to you.
Thank you. It's actually a quick answer. Today is my day for quick answers. This is something new that has popped up. So one of the changes I've seen across the Special Procedures Branch is we now seem to have more and more rapporteurs, as well as people within committees that have an increased knowledge of illicit financial flows and tax. And we do a lot of cross conversations. And so this is actually the result of conversations with my team and the mandate on foreign debt, because one of the things I've been doing for the past 3 years is to actually build up capacity across all the rapporteurs to start to better understand the implications of these very important issues on their particular mandates as well. So I'm glad to see it's popping up also. And thank you for raising it, Juan.
Thank you very much. That's great, Attiya. Did I see a hand up by anyone? No, maybe not. Maybe it's one of those.
Yes. So it was me to build on this. on this question, if I may.
Yes,
I'm
please.
breaking the rule of engagement. I think I'm making it more horizontal than it was supposed to be. But on Juan Ignacio's point, I think that the depth piece, which I didn't see in the transcript you made, but I see you mentioned in the question. I think that would be really kind of innovative for the Committee on Economic and Social Rights. I would say that in terms of innovation, that's a super innovation and probably has to do with Attiya's work. Then and some other, I'm not sure on the Inspectors Without Borders reference, which is fairly specific, but issues on enhancing, for instance, the capacities of tax administrations, I am aware that have been read as part of the duty to mobilize available resources in the past. So this first standard that I discussed, which is not only present in the Covenant on Economic and Social Rights, but also in the Covenant of the Rights of Persons with Disabilities, Rights of the Child, has been read broadly, right? So it includes things as strengthening the capacities of tax authorities to combat tax abuse.
Thank you very much, Emi. We have another question here as well from Matt that says, thank you very much to all the panelists for the interesting discussion. Much of what I have heard from the discussion in terms of the next steps seem to focus on the need for narrative change. Sorry, just change 1 second. Okay, for us to be able to explain the weaponization of privacy, to explain the cost of corruption and tax evasion. I would like to hear from the panelists some more on the strategies for achieving this narrative change. And Attiya has volunteered as well, and then we will have Andrés, who has put his hand up.
Thank you, Andrés. I'll be quick. I have 3 points to make on the issue of narrative, and I think it's very important. The first is that the narrative of human rights, if we're going to use this language that is human rights based in fiscal spaces, has to be really clarified as coming from a Southern perspective, because the Southern perspective is a very valid perspective, and there are more countries in the South than the North. And it's the sort of thing that can actually jeopardize the UN Tax Convention's content. And as a result, will actually jeopardize that across the world. The second is something I've noticed in the recent meetings at the annuals, which is the use of the word terrorist financing as one of the focus or foci that the IMF will be looking at, which has really surprised me and has given me some concern. Because if we use that language, then that is definitely going to be very much Southern targeted as well. Again, this is how diplomatic speak is going to show itself in the backlash in trying for us to get this convention through. And the third thing is where the word human rights is problematic. I think very often member states appreciate use of language like the raising of living standards. Sort of compromise language still means the same thing pretty much, can cause problems for human rights diehards. But when we're trying to get legislation passed, or when we're trying to get treaties in place, often we have to look at those issues. Thank you. Andrés, over to you.
Thank you. And I would say, again, I'm not an expert campaigner, I'm more of a research, but I would completely agree with what Maria Emilia said about like more evidence. So one thing that the Taxes Network produces is the State of Tax Justice, where we explain not only how much we estimate of tax avoidance or tax abuse, either tax avoidance by multinationals and also tax evasion regarding individuals, but also what that means in practice. Like all of these billions that are actually being lost in a way for countries could be used to pay for all these hospitals or nurses or schools and other things to make it a bit more real. In the paper that I wrote, where I was in a way responding to the ruling, I also gave examples that were given by someone else from Transparency International about the cost of corruption. So again, I think there's this very clear thing of like, well, terrorism costs lives. Well, corruption also costs lives. And so there's this case of in Argentina, this Cromagnon, a public disco that because of corruption had like no safety and like no, their exits were locked, and so all the people died in a fire. It was horrible. The case of Beirut and the port, the case of the earthquake in Turkey. So just showing corruption also costs lives. It's not just money that's being lost. So I feel like we need to build up more evidence to make it more tangible for people to be like, oh yeah, it's not only about fighting terrorism, that of course will have a cost in human lives, but corruption and the money that is lost to tax. So I guess more evidence or more cases just to make the evidence, as Emilia said.
Perfect. Thank you very much, Andrés. We have another question from an anonymous attendee who says, many thanks to the panelists for a very informative presentation. Can you talk more about how a tax justice and transparency approach might be applied to understanding the human rights problems associated with special economic zones? So please put your hand up. Yeah, Emmy, over to you.
Yes, I can start. So maybe actually this is a good example. And I think there are many angles and standards that relate to this issue, assuming that these zones have tax incentives, right, which they normally do. So first, there will be a need to assess these incentives in light of the maximum available resources principles, right? So it's not that states can just let go of their revenue under any circumstances and with no restrictions. So then there's first is that angle. Then there's also the transparency and accountability angle. Often these benefits are designed in a way that monitoring the impact that they have is really difficult. They're not subject to any evaluations, and there's very little information to really understand their impact, both in terms of achieving their goals, which are sometimes not really measurable, but also the impact of the revenue that is foregone on different groups. So definitely this other angle of transparency, which has to do with producing and publishing sufficiently disaggregated data on tax issues also comes into place. And I think there's a third angle that some of our colleagues in Latin America, such as Latindad and CESR through its initiative on human rights and fiscal policy are trying to push, has to do with an equity and specific gender assessment of this sort of measures. So it's not that just we want to assess how much revenue we lose, who is benefited, but in the end, which are the individuals and what's the composition of the group of individuals who benefit from this sort of measures. Because there's this intuition that when information is available, it's the most privileged groups in society who tend to benefit from this sort of state policy.
Thank you, Emmy. Attiya?
Thank you. So one of the things that one really has to watch with tax justice in this specific space of special economic zones is often in developing countries, once a zone is declared SEZ, very often nobody goes in to monitor other issues because it suddenly becomes almost an entity in itself. So what you start to see is a scenario where, since the tax inspector doesn't pop in, the immigration officer may not pop in, the labor inspector may not pop in, the water person may not pop in, and they more and more are developing themselves into almost countries within a country, and it's phrases that are used across the world. So the lack of enforcement or even monitoring and evaluation of the space becomes really problematic. And tax actually is a really good entry point sometimes because it's something everybody ideally should do. But I think the example that is the most interesting for me in the world right now is actually Honduras, where the SEZ was initially only supposed to be for export. And now, as it has grown stronger, you are now able to, because of political changes in the law, you're now able to actually sell 100% of the output domestically, but still not pay any taxes and still produce in the zone. And it became a question of lobbying and political favors. And it's fascinating because they're now setting up what they're calling the tax justice law, and it's been stuck in their parliament for 2 years. So even when we look at SEZs, we should look and see what happens at the end when you lose control of your power and your politics and your lobbying. And Honduras is a good example. Thanks.
Brilliant. Thank you very much, Attiya.
Can I?
Yes, please, Asha, go ahead.
Yeah, just on this special economic zones, I started reading a book called Cracked Up Capitalism, Market Radicals and the Dream of a World Without Democracy. So the author in this book quotes Peter Thiel, the founder of PayPal, and he says that I no longer believe that freedom and democracy are compatible. The great task for libertarians is to find an escape from politics in all its forms. If we want to increase freedom, we need to increase the number of countries. And the author basically said that actually we have 5,400 special economic zones scattered around the world. Most of them are in Asia, Latin America, and Africa, with only about 10% in North America and Europe. And yet the West are the main proponents of these zones. So, this book really puts it all into perspective. And these zones are supposed to be export processing zones, but they often, as Attiya was saying, end up being tax havens, laws unto themselves, without any oversight. And so the whole notion of democracy that we are comfortable with gets lost in it.
Thank you very much, Asha. I can see Andrés hand up as well.
Yeah, just want to comment on this, and I feel like I agree also, like Maria Emilia's point about how countries are affecting other countries. So I feel like the solution that we have at the taxes is that work with our indexes, where we always measure the worst case of any country. So a country can say like, well, I have transparency, I'm offering these, I'm doing all these good things, but of course, the exception will be the economic zone. So what we do when we assess countries is we always care for the worst case. So in our case, it might likely be the economic zone. So again, a country could not say like, I'm helping and I'm being a good student or a good partner to other countries if your economic zone is, of course, undermining all of that. So we should be rating or punishing countries based, again, on their worst case. And I feel like that approach can help.
Amazing. Thank you very much. I don't see any more questions. So I'm going to ask you a question now. One of those, like to end on a positive note, hopefully. So what do you feel most excited about in terms of having international human rights law as part of the terms of reference for the UN Tax Convention, or just the UN Tax Convention in itself? And we are going to go in the previous order. So I'm just trying to get you a little bit of space now to think of your answer. Okay. And in the meanwhile, if there is anyone from the audience who has a burning question, please feel free to put it in the Q&A. And if we don't have time to answer it live, we'll be able to type as well. So we are going to go in the order of Attiya, Asha, Andrés, and Emi. Attiya, over to you.
I was hoping you'd do the reverse order this time, but that's fine. I think there's no short way of saying this, so I'm sorry in advance. In 2010, I completed my doctoral thesis, and the area of originality was linking tax to human rights. And at that point in time, people told me I was crazy. They told me I was unrealistic. They told me it didn't make sense logically. And that in my lifetime, literally 14 years later, to be able to see this language in the terms of reference of what will be a treaty and hopefully an actual like physical connection, to be able to be part of this is incredible. But going forward, I think is now the heavy work, because while we've clearly made the connection for the member states in the world, that there is something there. I think what is really important is to flesh it out. And yeah, I think that for me is the challenge, but it's also the excitement. Thanks.
Perfect. Thank you very much, Attiya. Asha? You're on mute, Asha.
Sorry. So in preparation for this, I came across an article that was actually quite scary, because it brought up the issue that Andrés earlier on talked about, where the right to privacy is now being used to challenge automatic exchange of, to challenge the exchange of information treaties and that. So despite all these, what I call speed bumps or even potholes, despite all these right to privacy sort of problems within the human rights framework, for me, I think the most positive element of this is the underlying access to information, freedom of expression, perspective, changing the narrative, and just developing strategies. I'm just really excited about the potential to develop strategies to counterattack. And I'm really looking forward to the counterattack, where we weaponize access to information, and we say that the secrecy provisions that protect taxpayer confidentiality goes against the fundamental democratic right of access to information, and we win. That's what I'm looking forward to.
Amazing. Thank you very much, Asha. Andrés?
So I think that I think like why the tax network is so interesting, the whole UN tax convention, so as to get not just a bunch of rich countries defining standards for everyone else, but really having every country being able to have a voice and a vote in this sense. So this idea that we will no longer have like Europe that is so worryingly in the way that they are interpreting privacy, but now have other views like the cases Asha was presenting from Kenya and South Africa. I feel like that's very, very, I think, powerful. Just this idea that maybe the Global South has a much better solution from a human rights perspective to have and define this issue of privacy. So yeah, I'm looking forward to more case law and more inspiring cases that we can, or at least just to have like how to change the narrative.
Thank you very much, Andrés. Maria Emilia?
Yes, I like this question. So first, initially, I think something very excited, as Attiya pointed out, is it's at a personal level. This fight has been so long, and I don't think we could have imagined in a million years that we would have gotten this milestone. And we want to be responsible and take risks seriously, but it's a huge achievement. And it's not only because of our organization has been fighting for this for so long, but because of the political message behind that fight, right? Which has to do with really gathering as many tools and normative tools and universal tools to fight for a fairer tax system. It's not only about applying the law and policy coherence, it's like the strong message that is behind that. So I'm very proud as Latin America to see the Latin American countries advancing the robust reading of social rights and the right to development in these discussions. And then I think an exciting future-looking challenge is now fitting more specifically in this conversation with some stakeholders that have not been necessarily part of the debates that led to these outcomes. So there's going to be a learning phase and a re-strategizing phase that I think is what we are trying to start to do with this conversation, but that it's going to look hectic but exciting ahead.
Absolutely. Thank you very much, all of you. I think that my main takeaways, which have been, it's been such an interesting discussion, but I think that some of the things that we really need to remember from this are some of the issues that you have mentioned before. I really like Andrés, like difference between like privacy and secrecy. I think that that's key, and that's something that we need to keep in mind. I really like also the idea that the rights are not absolute. No matter what they say, the right to privacy is not absolute, because no rights are absolute. And it's a matter of proportionality, it's a matter of reasonability and justiciability as well. And also in terms of the core human rights issues that we were talking about, non-discrimination, we were talking about transparency as being one of the core human rights, and also about the maximum available resources and extraterritorial obligations that Emi was talking about. Those are key and are going to be fundamental in terms of guiding and interpreting what the tax convention is going to be about and how it really opens that potential for gender equality, for rights, for tax and the environment, for progressivity, for the effect of enabling countries, right, for tax abuse. All of that can be used because we have now international human rights law. As you were saying before, this is not to say that this isn't a risk. It is a real risk. It is very concerning that so much effort and so much money, let's say it like that, is going into really convincing, right? And just actually achieving those rulings against collective rights, against community rights, and just because of weaponizing the right to privacy in that sense, and weaponizing the right of professional secrecy. So I think that we also need to take as a takeaway that we need to be joining forces. And as Emi was mentioning before, this really requires different stakeholders, right? So it's not only tax justice constituency. We really need to have some lawyers involved. We need to have some economists involved. We need to have the gender equality, like women's rights involved, the climate justice constituency, because this is a matter that matters to all of us, right? Without financing, we cannot have rights. Like, we need to be able to resource rights. And that's why tax justice and this tax convention is so important to us. So I really would like to thank you all. Also, not only those who are currently in the audience for the great questions, but those who will be watching us. So many of you have been saying, I won't be able to make it there live, but I will be watching the recording. And I would like to thank all of you. Of course, Attiya, Asha, Andrés, Maria Emilia, but also Asha, who has been putting together all this amazing webinar. So thank you very much and have an amazing day. Bye-bye.
Thank you. Bye-bye.